what's more important, safeguarding your individual liberty or emphasizing the state to govern effectively? Today, we dive into a debate that shaped the very fabric of the Indian democracy, the due process versus procedure established by law. If you have ever wondered why Article 21 of the Indian Constitution isn't quite like its American counterpart, then this story is for you. Picture this. It's the late 1940s. India has just won independence and the Constituent Assembly is crafting a constitution for the world's largest democracy. Benegal Narsingh Rao, the principal advisor, visits the US and meets Justice Felix Frankfurter. The topic? A clause in the American Constitution's 14th Amendment, the famous due process of law. But Frankfurter warns Rao that don't copy us. The phrase will tie your judiciary's hands. But why? Because due process in the US had become a tool for courts to strike down economic reforms and welfare laws. For a young welfare-focused nation like India, was this risk worth taking? When Rao returned, he reported these findings to the Constituent Assembly. In response, the draft constitution replaced due process with procedure established by law. The change was subtle yet profound, shifting the power from judges to lawmakers. Do you think giving lawmakers unchecked power was the right move? Or should judges have had a greater role in protecting our freedoms? The debate over due process ignited fiery exchanges in the Constituent Assembly. B.R. Ambedkar, initially a supporter of the due process, faced opposition from leaders like Govind Vallabh Pant, who argued that land reforms and social justice initiatives will be hampered if courts can strike them at their own will. As a compromise, the Assembly adopted the phrase procedure established by law, which was codified in Article 21 of the Indian Constitution. However, members like K.M. Munshi and Alladi Krishnaswamy Iyer continued to advocate for stronger judicial safeguards. The ambiguity over procedure established by law became glaringly evident in the A.K. Gopalan case of 1950. A communist leader challenged his preventive detention, arguing it violated his fundamental rights. But the Supreme Court upheld his detention, stating, as long as the law follows a valid procedure, its fairness is irrelevant. This marked a grim moment for civil liberties as the judiciary deferred entirely to lawmakers. So would you trust a law that allowed indefinite detention without questioning its fairness? However, this tide turned in the Maneka Gandhi versus Union of India of 1978. When Gandhi's passport was arbitrarily impounded, she took her case to court. The Supreme Court dramatically reinterpreted Article 21, declaring that the procedure must be just, fair, and reasonable. This landmark decision reintroduced elements of the due process under a totally different name, sparking a judicial revolution. Cases like Sunil Batra, which talked about prisoners' rights, and Mithu, which emphasized mandatory death sentences, expanded these protections, moving closer to a substantive due process framework. As Rohan Alva highlights in his Liberty After Freedom, Maneka Gandhi's case wasn't just a legal battle. It was a battle for the soul of the Indian Constitution. But was it enough? Fast forward to the 21st century, and the due process debate remains as relevant as ever. In the Puttaswamy versus Union of India of 2017, the Supreme Court recognized privacy as a fundamental right under Article 21. Justice Chandrachud famously remarked that life and liberty must be safeguarded by fair, just, and reasonable laws. Recent cases like Aadhaar 2018 and Muhammad Arif, which talked about the death penalty review, have further tested the limits of Article 21. While the judiciary expanded individual rights, lawmakers have occasionally bypassed these safeguards. In his book, India's Undeclared Emergency, Arvind Narayan talks about how preventive detention laws remain a chilling reminder of colonial oppression. The National Security Act and other detention laws enable indefinite imprisonment without trial. Narayan writes, these laws weaponize the state against its citizens, creating a permanent shadow of fear. This enduring tension highlights the dangers of unchecked legislative power. More recently, acts like the Digital Personal Data Protection Act of 2023 and the Telecommunications Act of 2023 have raised several red flags. Critics argue that these laws undermine privacy and expand surveillance powers without adequate checks. So when does national security cross the line into mass surveillance? And can we trust our lawmakers to draw that line? Globally, the US Supreme Court has revisited its stance on the substantive due process, notably in the Dobbs versus Jackson of 2022, overturning Roe versus Wade. India, however, has taken a more progressive route, as seen in cases like the Nas Foundation, which decriminalized homosexuality, and Puttaswamy, which talked about right to privacy. Judges have frequently expanded unenumerated rights, often going further from their American counterparts. So as India navigates its digital future, the due process debate looms larger than ever. Issues like data privacy and algorithmic governance challenge the judiciary's ability to adapt. Justice Rohinton Nariman aptly remarked in Muhammad Arif of 2014 that the wheel has come a full circle. Substantive due process is now integral to the right to life and liberty. Others like Justice Chelameshwar caution against disregarding the framers' intent to exclude due process. So where do we go from here? Should India stick to its roots and trust lawmakers to embrace a robust doctrine of due process? The answer could redefine our freedoms in the years to come. Don't forget to like, share and subscribe for more such deep dives into India's constitutional history. Until next time, stay tuned to Newshamster. Thanks for watching.